சொல்லி அவங்க இதெல்லாம் தேடி நான் ஃபோன் பண்ணேன் சொல்லி கொஞ்சம் இல்லை நீங்கள் அவர் பார்த்தா ஒரு ரொம்ப சூட்டாக அதுதான் என்ன பண்ணுறேன் காலையில் சொல்கிறோம் கையில் எக்ஸ்பிளைன் மாத்திரம் 3 பேரை வந்து இது பண்ணுவாங்க. வைஸ் சேர்மன் சேர்மன்ல உட்கார்ந்தேன். guys welcome. இது இன்னொரு ஏதோ வருது. வர
May I now request the Honorable dignitaries to kindly adorn the stage. I request the Honorable Chief Justice, Honorable Mr. Munishwarnath Bandari to take the stage. I also request Honorable Justice P.Sathasivam, former Chief Justice of India and former Governor, State of Kerala, to take the stage. I also request Honorable Justice C. Nagappan, former Judge, Supreme Court of India and Chairman, State Law Commission, to take the stage, along with the President and Secretary of the Madras Bar Association. I kindly request the members of the audience to kindly keep your mobile phones on silent. Thank you very much. May I request the audience to kindly raise for the invocation song sung by Mrs. Daksha in meditation.
நீராறும் கடலுடுத்த நிலமடந்த கிழிலுருகும் சீராறும் பதனமென திகழ்வரத கண்பமிதில் தெக்கணமும் அதிசிறந்த திராவிடனல் திருநாடும் தக்க சிற பிறைநுதலும் தருத்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிழமை திரும்பியந்த செயல் மறந்த வாழ்த்ததுமே வாழ்த்ததுமே வாழ்த்ததுமே.
Thank you. May I now request Mr. B.R. Kamalnathan, the President of the Madras Bar Association, to give his welcome address.
My Lord, Honorable Mr. Justice Munishwarnath Bandari, Chief Justice High Court Madras. My Lord, Mr. Justice P.Sathasivam, former Chief Justice of India and former Governor of State of Kerala. Honorable Mr. Justice C. Nagappan, former Judge, Supreme Court of India. Chairman, State Law Commission. Honorable Judges of this Honorable Court, Honorable former Judges, Justice K.N. Basha, Justice T. Sudhandiram, Justice Akbar Ali, Justice B. Rajendran, Justice K. Ravichandra Babu, Dr. Justice Vimala, Honorable former Justice F.M. Ibrahim Khalifullah, Honorable Justice R. Balasubramaniam, Honorable Justice S. Nagamuthu, the law officers of the state and central, the office bearers of the various bar associations and Bar Council of India and Bar Council of Tamil Nadu, ladies and gentlemen, very good evening to one and all. It is indeed a great pleasure in welcoming the dignitaries for the unveiling of portraits of late former presidents of Madras Bar Association, Mr. M.Raghavan, Senior Advocate, Hon'ble Mr. Justice Kumar Rajaratnam, former Chief Justice of Madhya Pradesh, former Chairman, Securities Appellate Tribunal of India, Mr. K.Alagiriswami, Senior Advocate and former Advocate General of Tamil Nadu. The members of the Bar Association recollects and remember the great memories of the former presidents and their services to this great Madras Bar Association. Mr. M.Raghavan, Senior Advocate, was the Secretary during the year 1980 to 81 and was the President during the year 1985 to 1987. Honorable Mr. Justice K. Kumar Rajaratnam was the President during the year 1992 to 1994. Mr. K.Alagiriswami was the President during the year 2010 to 2012. I was one of the office bearer during his tenure. When we invited the former Chief Justice of India, the son of the soil, Honorable Justice P.Sathasivam, for this portrait unveiling function followed by a lecture, he immediately said, Kandipa Varamba, I will be happy to come to MBA. On 20th August 2013, the Madras Bar Association, Madras High Court Advocate Association, Women Lawyer Association, Law Association, in coordination with the Bar Council of Tamil Nadu and Puducherry, felicitated Honorable Mr. Justice P.Sathasivam on his assumption of office as Chief Justice of India. After that, this is next function being conducted by MBA. We thank Honorable former Chief Justice of India for consenting the same. Our bar-friendly Honorable Chief Justice and Honorable Mr. Justice C. Nagappan also immediately accepted our invitation for this historic function. We wholeheartedly thank the dignitaries for having given consent for this historic function. On behalf of the Madras Bar Association, we once again welcome the Honorable Chief Justice of our High Court, Honorable former Chief Justice of India, Honorable Justice C. Nagappan, judges of this Honorable Court, former judges, officers of the state and central, senior advocates, office bearers of various advocate associations, both principal seat and Madurai, the relatives of the Honorable Justice Kumar Rajaratnam, particularly son and daughter Abdu Kumar Rajaratnam and Mrs. Vijay Kumari Rajaratnam, and wife and son, daughter-in-law of Senior Advocate Mr. K.Alagiriswami, and relatives of Mr. M.Raghavan, Mr. M.S. Subramaniam and M.S. Bharat, and all others. Hearty welcome to one and all. Thank you. I missed to state Honorable former Justice of Jammu and Kashmir, Justice Paul Vasnakumar.
Thank you, sir. May I now request Mr. M. Ravindran, Senior Counsel. May now request Mr. T.V. Ramanujam, Senior Advocate and former President of the Madras Bar Association, to honor the Honorable Chief Justice of the Madras High Court with a memento and a shawl. May I now request the President of the Madras Bar Association, Mr. V.R. Kamalnathan, along with the office bearers of the Madras Bar Association, to kindly felicitate Hon'ble Justice.P.Sathasivam, former Chief Justice of India and former Governor State of Kerala. May I request again the President and Office Bearers of the Madras Bar Association to honor Honorable Justice C. Nagappan, former Judge, Supreme Court of India and Chairman, State Law Commission. Mr. Kumar Rajaratnam, the son of Justice Kumar Rajaratnam, would like to present a beautiful painting to the dignitary of the dais. We also request the family members of Justice Kumar Rajaratnam to join Mr. Kumar Rajaratnam on the dais, please. Thank you, Mr. Kumar Rajaratnam and the family of Honorable Mr. Justice Kumar Rajaratnam. Going ahead with the proceedings of the evening, may I now request Honorable Mr. Justice Munishwanath Bandari, our Honorable Chief Justice of the Madras High Court, to kindly unveil the portrait of Mr. M.Raghavan, Senior Advocate and former President of the Madras Bar Association, and also kindly say a few words to the gathering. May I request the family members and juniors of Mr. M.Raghavan to kindly join the stage. request the family members and juniors to kindly join the stage at the earliest.
No, wait na. Last me.
అది నా లో యాంగిల్ ఇస్తున్నా నా లో నా ఎత్తిడియానా సార్ 1 సెకండ్ నా ఎత్తిడియానా సార్ 1 సెకండ్ సార్ ஓகேவா ஓகே சார் தேங்க்யூ அதெல்லாம் இதுக்கு முன்னாடி அங்கே என்னன்னு வச்சுக்கலாம் ஊரை பற்றி சொல்லுவாங்களா ஊரை பற்றி சொல்லிட்டு தான் வரணும்னா லேட் ஆகும் நான் அவரை பற்றி சொல்ல போகிறேன்னு நினைக்கிறேன்
Welcome and very good morning, good evening to one and present here. Honorable Justice P.Sathasivam, former Chief Justice of India and ex-Governor of the State of Kerala, Justice C.Raghavan, former Judge of the Supreme Court and now the Chairman, State Law Commission, Tamil Nadu, galaxy of former judges of Madras High Court and who remained the Chief Justice of J&K, my dear brother and sister judges present here, family members of Mr. M.Raghavan, K.Alagiriswami and Kumar, Rajaratnam, all the family members are there. The member of Bar Association, bar members, senior advocates present here. At the outset, I would commend the members of the Bar Association for organizing this function to unveil the portrait of Mr. M.Raghavan, K.Alagiriswami and Shri.Kumar Ratnam. They all remain president of this prestigious Bar Association. And when this offer was given to come and unveil the portrait of one of the president of the Bar Association who has contributed a lot, immediately I accepted it. The reason being that I also remain the president of the bar. So it is very close to my heart. Thinking that portrait is not just a picture, it is a recognition of the excellence and contribution of the advocate who has given to the bar. It is to be recognized by us, and I give credit to the Bar Association that they could recognize the contribution, the excellence of few members who remain the president of this prestigious bar. And especially in the august presence of Justice Sathasivam, who is considered to be second Chief Justice from this court, though if we go with the origin, I mean he was the first from Tamil Nadu. All credit to him. So his presence makes a lot of difference, and along with that, the presence of former Chief Justice of the Supreme Court and judges of this prestigious High Court. I am presently one of the member of this prestigious High Court, sharing the responsibility as the head of the family, and these types of program really comes very close to the heart. Remaining a member of the bar, knowing about the activities of the bar and the contribution of the bar members. It is the members who contribute even in the institution, the prestigious institution is also recognized with the contribution of the bar members. So this is the real time to recognize their contribution, their excellence, and these luminaries which remain even the president of this prestigious bar. I extend my sincere thanks to the president of MBA bar and all the office bearers for organizing this function. This is just a recognition of few very excellent work they have taken, and I have been asked to speak about Mr. Raghavan, a small sketch of his life that I would be giving. He was a brother of the former judge of this High Court, who remained the judge of this High Court between 1964 to 70. He was born on 11/11/23 and his schooling at Tiruvallur district. He completed his BSc degree and thereafter he joined the bar initially at Chengalpet district, and soon thereupon he came to the High Court. He did his practice, more especially company laws and writ, and on his own merits. Raghavan held office of the government pleader and dignity between 64 to 69. He remained as a government pleader office. He shifted his practice in Chennai, as I've said, and initially he joined the office of Devadasan and Sagar, and thereafter he independently practiced. He was recognized by the judges of this High Court due to his excellent presentation of the cases, and soon he was even elected as the president of this High Court Bar Association. He has contributed a lot for the welfare of the bar members, and all this is recognized now today on unveiling of the portrait. Not taking much of the time, I'll extend my hearty thanks to the members and the president of the bar to invite me and to grace the occasion. Thank you so much.
Thank you, my Lord the Chief Justice. May I now request Honorable Justice P.Sathasivam, former Chief Justice of India and former Governor of the State of Kerala, to unveil the portrait of Mr. K.Alagiriswami, Senior Advocate, former Advocate General of the State of Tamil Nadu and former President of the Madras Bar Association. May I request the family members of Mr. K.Alagiriswami to kindly join the stage, participate in the unveiling, and also honor Honorable Justice P.Sathasivam.
ఫోటోగ్రాఫర్స్ కొంచెం లైట్
సార్
சார் இன்னும் கொஞ்சம் உள்ளே போங்க. சாப்பிட்டு போடுறாங்க கொஞ்சம் திரும்ப நம்ம
May I request His Lordship Justice P.Sathasivam to say a few words about Mr. K.Alagiriswami.
High dignitaries on the diet. Now I will specifically mention when my lecture term comes. Other invitees, office bearers of MBA, and the family members of most respected Mr. Alagiriswami. I need not elaborate his career. Even now I remember his chamber in the second floor, that corner, small chamber, nobody can go there. He has above the Chief Justice lift, his chamber, I know that. nobody can go. This is the last area. So always I noticed his smiling face. Even at 4 o'clock or after quarter hours, normally we others will get tired. But normally he keeps very smile, and he comes from Srivilliputtur. I have one connection, though I come from western part of Tamil Nadu. I had the opportunity to finish my graduation in Sivagasi. After Sivagasi, only Srivilliputtur is there, near next to Taluk. And his further details show that he was a sportsman, both in the school days and college days. And he had the opportunity to work under very reputed seniors. Both of them served as judges of the Supreme Court, Justice Ramasamy, initially Justice Ramanujam, and Justice Ramasamy and Justice Mohan. And he also served, apart from central government service, also served as Advocate General of the state. And he was a secretary of the Rule Committee nominated by the High Court. It is very rare occasion. And I'm happy to unveil the portrait of Mr. K.Alagiriswami, and I convey my thanks to the office bearers of the Madras Bar Association for giving me this opportunity. Thank you.
Thank you. May now request Honorable Mr. Justice C. Nagapan, former Judge, Supreme Court of India, Chairman of the State Law Commission, to unveil the portrait of Honorable Mr. Justice Kumar Rajaratnam. May I request the family members to kindly join the dais. May I request Honorable Justice Nagapan to speak a few words about Honorable Mr. Justice Kumar Rajaratnam.
Honorable the Chief Justice of Madras High Court,
Justice Munishwarnath Bandari, Hon'ble Justice P.Sathasivam, my brother and sister judges of the Madras High Court, Justice Ibrahim Khalifullah, former Judge Supreme Court, Justice Pal Vasnakumar, former Chief Justice, Jammu and Kashmir High Court, my beloved former judges, Mr. Kamalanathan, President of Madras Bar Association, Mr. Srinivasan, Secretary of the Association, other office bearers and members of the Bar Association, office bearers of other advocate associations, senior advocates, members of the bar, family members of the past presidents of Madras Bar Association, ladies and gentlemen. I deem it both a privilege and honor extended to me in the opportunity given to unveil the portrait of Justice Kumar Rajaratnam, former President of Madras Bar Association and former Chief Justice of Madhya Pradesh High Court. Hailing from a distinguished family of Madras, Justice Kumar Rajaratnam was called to the bar by the Honorary Society of Gray's Inn in 1970. He was the first Indian to be elected as President of the Gray's Inn Debating Society, London. He was the recipient of Mountbatten Scholarship to read for the bar and practiced at Assizes Court, Oxford during his pupillage. Subsequently, he joined the Madras Bar and was in the chambers of late Justice Rathnaveli Pandian, former Judge of the Supreme Court. Justice Kumar Rajaratnam appeared in leading criminal cases, namely Mustard Roll case, Leela Rani double murder case, and the Pethodin murder case. He made a mark in the appellate criminal side and also appeared in constitutional matters. He was soft-spoken in nature and possessed a natural gift of eloquence. His advocacy was flawless and impressive. His greatest respect to the court and very polished and dignified manner of presentation of facts with utmost fairness raised him to the pinnacle of glory. He was the first barrister to be appointed as a judge of the Chartered High Court after independence. He was a great lover of sports and took part in rifle shooting competition. He was also a keen tennis player, groomed by the legendary player Ramanathan Krishnan. He was the elected president of this bar association for 2 consecutive terms. Shortly after assuming office as judge of this court, he was transferred to Karnataka High Court. He earned the goodwill of the members of the bar of Karnataka High Court and was held in high esteem. Both the bar and bench affectionately called him as gentleman judge. This is out of my personal experience. I have interacted with him. I know this family for a long time and I have interacted with all of them. And Justice Thakur, I usually know. Justice Kumar Rajaratnam was elevated as Chief Justice of Madhya Pradesh High Court in September 2003. After his retirement, he was appointed as Presiding Officer of Securities Appellate Tribunal, Mumbai in 2004, and he was appreciated by investors, institutions and brokers alike. I have to say something about the wife of Justice Kumar Rajaratnam, Mrs. Hira Kumar. She hails from a prominent family in Bangalore. I still remember the good assistance given by Mr. Abdu Kumar Rajaratnam as additional public prosecutor when I was dealing with criminal matters as a judge of this court. On my elevation, nearly for 3 to 4 years, in 2001 to 2005, mostly I was given criminal work, assigned criminal work in the bench. Kumar Rajaratnam was representing the government and as public prosecutor. So the faith I had on him, there's a kind of a personal touch. The public prosecutor, I want to tell, though he was young, he was up to the mark. And I used to tell him, if you don't get instructions, ask for time. But whatever the IO says, don't come and say it here, unless you see the CD file. And mostly in important cases, without instructions or without going through the file, because I pass orders on your submission. He was very careful, doubly careful. He saved my name also. I am also happy to know that the grandson of Justice Kumar Rajaratnam has joined the bar, and I am confident that they will carry forward the legacy. I thank the members of the Bar Association for having given me this opportunity to address you. Thank you.
Thank you. Below request, Honorable Mr. Justice P.Sathasivam, former Chief Justice of India, former Governor of State of Kerala, give his lecture on the recent trends in judicial reforms, global perspective. Thank you.
Honorable Mr. Justice Munishwarnath Bandari, Chief Justice of High Court Madras. Honorable Mr. Justice Nagapan, former Judge, Supreme Court of India and Chairman, State Law Commission. Honorable brother and sister judges of the Madras High Court. Former Judge of the Supreme Court, my friend and former colleague, Justice Ibrahim Khalifullah. And former judges of the High Court, this court, and Justice Paul Vasantakumar, former Chief Justice Jammu and Kashmir, Mr. V.R. Kamalanathan, President, Madras Bar Association, Mr. D. Srinivasan, Secretary, Madras Bar Association, respected senior advocates, members of the bar, particularly Madras Bar Association, my lovable young advocates present here, and family members of the three respected dignitaries and my friends in media. A warm good evening to this august gathering, and I am delighted to be here in my parent High Court, where I started my law career almost 50 years ago. In the same month, July 1973, I entered this building. Today, I can remember 50 years ago, I entered as a Raw Junior. This pleasant evening with friends and colleagues bring back my fond memories of early legal career days. My journey started as a farmer's son, government school, government college, government law college, then in the office of Shri K.Alagiriswami, respected senior advocate, and as a state law officer, then elevated to the bench of this court as a permanent judge, later as a judge of Punjab and Haryana High Court, then elevated to the Supreme Court, followed by the honor of rendering judicial service in the position of 40th Chief Justice of India. Later, rendering service as an executive head of state of Kerala, and finally returned back to my farming house in my native place, which is western part of Tamil Nadu. This journey is my biggest reward. Experiences and good friends earned were added bonus. I am grateful to MBA members, as rightly said in the introductory remark. Only when I assumed as Office of Chief Justice of India, I came here. Whether right or wrong, as a judge, I avoided outside functions. Even I avoided several international conferences, because my duty is to do more work in the judiciary. That is the allotted field. So I am grateful to the MBA members, office bearers in particular, for bestowing upon me this opportunity to speak to you all after a long time, maybe 9 years after my earlier entry. I hope that the deliberation and reflection in this lecture series organized by MBA will have some practical relevances for both the bench and the bar. It is my absolute pleasure to kickstart the MBA lecture series after the COVID breakdown. Still, we have to be more cautious and follow government's instructions. The topic: recent trends in judicial reforms, global perspective. Now, I will later say why I selected this topic. Periodic judicial reforms constitute an indispensable element in a relief-oriented society that is governed by rule of law and the principle of self-responsibility. Judicial reforms touches on several issues like access to justice, accountability in judicial appointments, etc. However, in today's speech, I am going to share my views on three aspects which is usually not discussed a lot, but according to me, it is a vital if we want to see visible improvement in our judicial function for the benefit of our country's advancement in global sphere. First, domestic law engaging with international law. Second, continuous judicial learning and judicial discipline. Last, tracing the evolution of our legal profession globally and how it is influencing us. At the outset, these three issues may seem distant to some of you, and in fact, you may wonder why this retired judge, aged about 73 years, old Kisan, and settled in a remote village, is talking to us about these aspects when there are other compelling topics to address under the ambit of judicial reforms. My dear fellow colleagues, comprising both the bar and bench, believe me, I have a strong reasons behind choosing these three aspects to talk to you on today. Thus, I seek your humble attention throughout my address, and I shall reveal my cause to you at the end. Let me start with the first aspect, namely domestic law engaging with international law. The growing relevance of international law for domestic courts started when the liberalization and globalization of Indian economy began 2 decades ago, as it brought individuals directly under the radar of international law. Until then, international law was seen as the business of the government, and the judiciary as an institution had less occasions for interactions with this subject. The key characteristics portrayed of globalized world are modernization, economic interdependence, role of transnational actors, increased interaction between state and civil society, communication revolution. No doubt this movement of liberalization and globalization has certainly put as well as in the lap of luxury. At the same time, it also opened more avenues for source of indifference, friction, instability, enmity, and conflicting among individual human beings. India is a party to more than 160 treaties and conventions dealing with various fields of law. Prominent among them are human rights, environment law, trade law, intellectual property rights, alternative dispute resolutions, cyber laws, space law, and maritime law. Consequently, the workload for our institution is also diversified, and we, the judiciary wing, have been called to represent and defend and to judge these diversified issues for the preservation of both individual and corporate rights. I had personally witnessed this transition from 1990s to till date, wherein the application and inclusion of international law within our judicial system has been gradual and consistent. I noticed that after 2014, the swiftness at which this transition progressed is astonishing. Think about it. A large chunk of cases that you deal with today, either as a legal counsel or as a judge, comprises of vast
subject domains of international law. The permeating, meaning to spread through something and be present in every part of it. The permeating nature of international law today regulates many things such as environment, trade, investment, intellectual property, general commercial litigation, health care, labor, security litigations, tax issues, health, human rights, etc. I am sure senior advocates and sitting honorable judges of this court will vouch for my statement. To make it easily comprehensible, let us refer to few cases. I will give one or two cases. Whenever we speak of domestic law engaging with international law, we cannot overlook the famous Visaga case in 1997. This was a writ petition filed by Visaga, a women's right group for enforcement of fundamental rights of working women under Article 14, 19 and 21 of the Constitution of India. The immediate reason for filing this writ petition is an incident during 1990s wherein Banwari Devi, a social worker, at that time she was also a state government employee, was brutally gang raped when she tried to prevent a child marriage. The Rajasthan High Court acquitted the accused rapist. This incident led to nationwide protest, specifically from women's rights group called Visaga, who ultimately filed a PIL in Supreme Court to address the issue related to the sexual harassment to which a working women may be exposed to. Three main contentions raised in that petition. One, whether cases of harassment violate the fundamental rights of women under Article 14, 15, 19, 1G and 21. Number two, to provide safeguard against the hazard to which working women may be exposed to. Number three, whether in the absence of legislative measure, court could apply the international laws to fulfill urgent societal need. Third may be very relevant for our honorable judges. The Supreme Court reiterated that each such incidents of harassment at the workplace to women violated the fundamental rights of women, that is, right to gender equality and right to life and personal liberty. Incidents like these are not only against the fundamental rights guaranteed under Article 14, 15 and 21, rather they also violate the victims of fundamental right under Article 19 1G, that is right to practice any profession and to carry out any occupation, either trade or business. One of the major contentions involved in this case was related to the ambiguous definition, sexual harassment, since there existed no domestic law. It is relevant because many of the orders we are reading in the newspaper, they are going beyond their statute. Since there existed no domestic law to check and provide remedial measures against such draconian act of sexual harassment of working women at all working places, the Supreme Court entered into the realm of contents of international conventions and norms for the purpose of clear and unambiguous interpretation of gender justice, gender equality, gender discrimination and gender-based sexual harassment. It held that as per provisions of Article 51 and 253 read with entry 14 of the Union List in 7th schedule of the Indian Constitution, any international convention not inconsistent, this is relevant, any international convention not inconsistent with Part 3 of our Indian Constitution, must be read to enlarge the meaning and content thereof to promote the object of constitutional guarantee. Further stated that governance of the society by the rule of law mandates and requirements as logical concomitant of the constitutional scheme. Since there existed no domestic law at that time to check and provide remedial measures of harassment of women at workplace, judiciary at that time laid certain rules and guidelines known as Visaga guidelines. The guidelines were in consonance with the international conventions and treaties regarding gender equality. One such convention was Convention on the Elimination of All Forms of Discrimination Against Women, whereby every signatory to it has to take steps in order to eradicate discrimination against women. The Supreme Court relied upon these commitments for the purpose of construing the nature and ambit of constitutional guarantee of gender equality in our Constitution. Likewise, I will give two more cases very briefly. Neelapatti Behra versus State of Orissa in 1993, a provision in the International Convention on Civil and Political Rights regarding doctrine of legitimate expectation was referred to support the view taken that an enforceable right to compensation is not alien to the concept of enforcement of guaranteed right as a public law remedy under Article 32, distinct from the private law remedy in torts. Another one more case in Jija Ghosh versus Union of India in 2016 reaffirmed the rights of persons with disabilities to live with dignity. This case arose from a public interest litigation that was filed when SpiceJet airline forcibly deboarded Jira Ghosh because of her disability. They refused to allow her to enter the aircraft. The Supreme Court held that the airline's action illegal and ordered it to pay 10 lakhs as compensation to the petitioner. In reaching this conclusion, the court also referred to international law to underline the rights of persons with disabilities. Now, I can also cite my own judgment, but I don't want to take more time. These trends clearly establish that the domestic courts are frequently invoking international conventions and norms in their decision-making process. This being so, it is immensely important for you to have a clearer understanding of international law and its interface with the domestic legal system, and also understand the constitutional basis that permit us to invoke international conventions and treaties. Doctrine of monism and dualism. You may not have gone through these two doctrines. Historically, the doctrine of monism and dualism have been used to understand the relationship between international and domestic order. According to monistic approaches, international law ought to be automatically incorporated into the domestic legal order without the requirement of any additional act of adoption or transformation by the state. Dualist, another principle, however, believe that international and domestic law operate a distinct sphere, and so the only mechanism for the transformation of international law into domestic law is through medium of regular domestic law-making process. This second dualist says unless the local government, our government have corresponding law, you cannot apply these international treaties. India follows the dualist theory of international law. Therefore, international law principles and norms cannot be invoked in domestic courts without being expressly incorporated in the domestic law. Our courts in certain cases digressed, meaning to move away from the main subject. I am not blaming anyone, that unfortunately that is happening nowadays. Our courts in certain cases have digressed from this doctrine of dualism, giving rise to confusion regarding relationship between international law and India's legal system. The courts have held that in the light of provisions of Article 51(1) of the Constitution, treaties to which India is an ascending party should be implemented in good faith. So they have to verify whether that part in that treaty, whether India is a party, accepted that treaty. Then only court gets power to apply that law. Article 253, it is stated that the executive cannot be directed, state cannot be directed to follow the treaty in the absence of domestic law. That is provided in Article 253. However, paradoxically, treaties are considered self-executing. That is, they apply in the domestic sphere automatically, except where it required an amendment to the Constitution or an existing law, or where new law is required to be enacted. Therefore, there is prevailing view that courts can take aid of a treaty principles which are not inconsistent with the provisions of laws in India, like in the cases discussed above. I mentioned only 3 cases. Unfortunately, the courts have used international law norms with cheerful abandon and offered little by way of justification and explanation for this move. This has invited criticism that has judges judges assert international law for its status as opposed to engaging with its content. This failure of the court to justify its use of international material is of legal significance. Take for example Narmada Bachao Andolan versus Union of India, wherein the court relied on ILO Convention 107 just because it was a law at that time, despite the fact that it was being hotly debated for its assimilationist and paternalistic approach towards indigenous population. This convention came to be replaced by Convention 169 later, initially 107, later 169. Thus, read against the jurisprudence as a whole, Narmada was a mistake. Had the court engaged with the reasons underlying the convention, it would have made it harder to overrule. No doubt, greater role is being played by the judiciary in developing human rights jurisprudence in India based on international principles. But be mindful of your actions. Lawyers, please be aware of source of your arguments when you submit to the court. Likewise, the honorable judges, do your independent research and apply your mind before you accept any submissions sourced from international law, because there has been instance when courts have favorably referred to treaties to which India is not even a party. No, because of paucity time, I am not mentioning though, I am not citing those cases. All that I wish to tell before I wind up this section is that in pursuit of rendering comprehensive justice, do not transgress your powers. Remember, the doctrine of separation of powers is the foundation of democracy. We cannot, I'm not saying you have no power to issue direction to the government or any other body, but we must also respect the other forums. That is my request. Moreover, the application of international law in the domestic sphere in India can be understood through the interpretation by the courts in its various decisions. Thus, you have a larger responsibility apart from rendering justice to the concerned individual. Your work in the court is the face of our country. I repeat, your work in the court is the face of our country in the global arena. Since the legal status of our international obligations in respect of the Constitution can be analyzed by a study of various judgments of the court. I will finish it off within another 5 minutes. Number 2, continuous judicial learning and judicial discipline. This is my second subject. I draw a distinction between the concept of education and learning. Judicial education is rendered in universities by professors, whereas judicial learning is imported through discourse like this and observation. There are numerous forums to gain the judicial education, so I am not elaborating much on it, but the environment for judicial learning is not always readily available. This is where Bar Association can play a pivotal role. Attending conferences, topic-based gatherings like today, symposiums, seminars by stalwarts in the respective fields, or even a coffee table discussion with your colleagues in the cafeteria after court hours will constitute as judicial learning. It is through these outdoor intellectual deliberations that we shape and develop our law. It would also enhance the awareness of the subject in the public domain. This facet of judicial learning is the dire need. The seniors in the fraternity should stimulate and promote it, as it will help us to expand our horizon and steer us to explore more areas. Remember, my dear lawyers and judges fraternity, over time, it is only such deliberations which will keep us updated, and at the same time, it will help us to develop an attitude for appreciating different perspectives on a topic. Remember, it is the vigor of learning in each of us that actually makes the judiciary thrives in turbulent times. Make it a habit to attend at least 1 or 2 conferences in a month. Besides the judges, the code of conduct requires he or she to be bit secluded from the public to maintain judicial fairness and impartiality. However, this isolation should not become intellectual isolation. This could have dangerous repercussions in justice rendering process. At the same time, there should not be exclusiveness when it comes to discourse. A free discourse across different factions is always a healthy deliberation. Next, judicial discipline. Judicial discipline is not only about punctuality, I can say it is my asset, integrity and maintaining professional routine, rather a substantive discipline that needs to be preserved in our profession is to maintain consistency and not deviate from our designated duty, notwithstanding the unfettered discretion in our hands. The reason why discretion is bestowed on judges is to avoid injustice, not to grant justice at your individual discretion. Understanding the substance of this difference is paramount. In the initial days of judging, I had this predicament. As you all know, my other profession apart from law is farming. From the day one, when I returned from my school, my father asked me to take 2 cows for what is that? Mekkiradhukku. Tamil. That was my part of my life, grazing. Profession apart from law is farming. As you all know, my other profession apart from law is farming. I always say through the years I farmed and judged simultaneously. So when cases relating to farmers' right came before me, I had ample practical knowledge on the subject. This definitely was to my advantage, but I used it with a restraint. My background and experience should only as a knowledge-based assistance for the judging process. I should not bring in my compassion for the issue to my judging process. This distinction should always, all times, be rigorously maintained. It is this dominant judicial discipline that needs to be nourished and practiced. For example, in any given petition, you cannot grant remedies beyond the prayers by invoking your discretion. It may seem like justice at that moment, but in the long run, it will only render injustice because it takes away core of our institution, which is consistency and predictability. Why I added this sentence, nothing wrong in disclosing. Now we are unfortunately having this COVID 2019. The World Health Organization is there, the powerful health body. It gives instruction to all over the world. And Government of India is there. Eminent health scientists are there. They give instruction to various states. And state governments are also having good officers. How to issue direction to the victims, how to directions to the people to have vaccination, etc. Unfortunately, I read one order from the highest court. You means government cannot direct anyone to have vaccination compulsorily. How we are justified? Or we have that knowledge about COVID and other health organization. That's why I purposely brought this line to convey this to the public. If judiciary is not consistent and predictable, then with time we will certainly lose the trust of the public for whom we are actually functioning. Last one. Tracing the evolution of our legal profession globally and how it influencing and changing us. The last decade has been mini revolution in legal service sector with the best legal impact on corporate legal arena. Activities in project financing, intellectual property protection, environmental protection, competition law, corporate taxation, infrastructure contract, corporate governance, and investment law are practically obscure before 90s. The numbers of law firms capable of managing such work were also very limited. Even though globalization is not new, but in the horizon of legal services, it is now gaining momentum due to the growth of internet, computerization of legal process, developments in data security, and emerging technological tools. It is clear that need of professional service has been tremendous in the legal service sector. As a result, recent years, number of law firms, in-house firms, individual lawyers with expertise in providing legal services in corporate fields has increased exponentially. Globalization has extended the inward and outward demand for legal services. Domestic law firms are expanding their services beyond local jurisdiction, joining forces with the foreign counterparts and forming international mergers, demolishing traditional boundaries on the geographical scope of practice of law. Likewise, law firms continue to expand their presence globally. Few Indian firms have set up their branches across their jurisdiction like UK and US. Certainly, global integration in the legal profession would help India in increasing her share in the global service trade. The legislature and the Bar Council of India's approach is not clear. On the legislator and the Bar Council of India's approach is not clear on the opening of legal services sector in India. The overriding view is still against foreign law firms setting up offices in the country, as apprehension thrives about probable stiff competition from foreign firms owing to their better infrastructure, better knowledge, and developed skills of legal drafting and documentation. Without a doubt, globalization will continue to reshape the landscape of legal industry in the coming years. But before that occurs, we should build a strong professional fortress with the highest institutional decorum, matching to the Western countries, and at the same time maintaining our identity. Because we cannot hold up the liberalization of legal services for a long time, sooner or later foreign firms and lawyers will be allowed to set up their branches in India, and we should build our capabilities, improve our infrastructure, and cultivate strong judicial discipline to sustain in the global legal market. My conclusion: the reason I chose to speak to you all about these three topics is because over the last 50 years of my service, I visibly saw how judiciary is evolving with increased interactions with other countries. Three discussed aspects: ongoing evolution of judiciary. In times to come, movement will grow only stronger and not less. Thus, wise thing we can do is to ready to face incoming challenge of globalization rather than shying away from it. Always remember, irrespective of stiff competition, it is our foundation. If our foundation is strong and durable, we will only grow at all times and never diminish. The rule of law is built on the cornerstone of an independent, efficient, and effective judicial system. With a well-functioning judiciary, the rule of law becomes more realistic goal, and citizens develop a greater expectation of and confidence in the legal protections and predictability that the system can provide. The impact of these protections and predictability on economic development is profound. Improving effectiveness of judiciaries is essential for promoting sustainable economic development of our country. Thus, you are not merely rendering justice to the individuals, but also concurrently creating a conducive environment for economic and social development of our country. Before resuming to my seat, because our honorable judges are also there, lawyers are also there, is my humble request. Nothing to do with my topic. That's why I requested Chief. I conveyed he wanted to leave, have some urgent work. I said, sir, I have something to you also. So I requested him. Regular monthly Lok Adalats to be conducted, preferably on Saturdays. It is going on. I am not denying it. But under the, because of this COVID 2019, last 3 years, not much mood, not much development. It should be. Now, if time permits, I can show number of illustration how it happened during our tapes. Brother Kalifullah is there, Brother Nagapan is there. And old civil disputes like partition, why you are mentioning, after 2014, I served 5 years in Kerala. Then 2019 September, I returned to my field. When I visited my field, after the boundary of my field, there are number of Vella Vela, and I don't know in English, Vela Mara, Mullu Chedi, 10-year, 15-year-old, in about 13 acres. I called the owners, they said, sir, we have a partition suit 13 years ago, partition suit among brothers and sisters. It is still pending in 4th Additional District Court, that is in Bhavani, in my taluk. I requested all the lawyers and parties, including the judicial officer, madam, is a lady officer. I said, I myself delivered several judgments. When I come to the field, it is different. The neighboring land, the parties are waiting for 13 years in a partition suit. Think of, then first appeal to High Court, another 10 years. If Supreme Court issues notice, another 15 years. Then final degree. Even our High Courts may entertain against final degree. How to divide palmyra trees. Likewise. So then the judicial officer said, sir, within these 13 years, 3 deaths have taken, that is the reason. Then I asked her to verify. On the first death, I'm sorry to say, the counsel said, so-and-so died. Then he left. The judge merely adjourned for steps 3 months. My humble request, while informing the court so-and-so died, why don't you mention the following are his or her legal heirs, her age and address. If the other side has no objection, the judge himself can record and include it, post it for trial. For taking steps for each death, subordinate courts, I am sorry to say, they take 1 year to 2 years. Still pending. I don't know when that suit is going to be. Then motor accident claim cases, land acquisition cases, labor matters, matrimonial disputes. Advocates have to convince their litigants to accept for a reasonable settlement. Encourage mediation and conciliation. Avoid unnecessary adjournments. I need not draw the attention of CPC, amended CPC. Maintain punctuality. That is must. We should not waste a single minute during working days. Now I can cite only one example and complete it. During my tenure, you know, Supreme Court, Monday and Friday are miscellaneous days. Normally 60 to 75, maximum 80 miscellaneous matters. I have a highest regard for I worked under him, Justice Markandeya Kachu. He's a very intelligent judge. By 11:30 or 12 o'clock, we will finish up, his car will go out of Supreme Court. And I verified, what is the reason, brother? No, I finished my work. Then I persuaded, so after the miscellaneous work, add 10 final hearing matters. We are supposed to work till 4:30 or till the court time. Many judges, even the 10 likely to be over by lunch. No, why I am saying we should not waste our time. Then complete pleadings early. This also, how many adjournments for written statement, counter, reply, rejoinder. Then shorten your arguments. Written arguments are preferable. And encourage settlements through Lok Adalat. And one more request before resuming seat. Administrative and portfolio judges have to visit their district at least once in a month. I am happy to note now, because the strength is more, Now Honorable Chief has allotted one senior judge, one more younger judge, I won't say junior judge, to each district. Nothing wrong. After all, they are going at the government expense. Where you have to visit on a holiday to visit your district. Meet the office bearers of the bar. They may have several grievances. They may have some complaints against judges. They may have some other issues. They cannot come and meet our Chief Justice directly. Is it possible to enter his chamber? Not possible, by virtue of his office. So, if a portfolio judge goes, he can note down all those things, then he can. And I will, Chief, I will ask my Hero district lawyers to come. The portfolio judge, after noting down, he can meet the Chief Justice or the Registrar General and take remedies and meet the office bearers of the Bar and Advocates Association, interact with the judicial officers. This is important. Can a poor municipal and magistrate go and speak to our chief? Even if he visits Coimbatore or E-Road, I don't think the PDJ will allow a municipal go and sit near him and explain. No. So they have several grievances, sir. At least for transfer, husband may be working somewhere, wife may be working. While transfer, if possible, can be posted in same district or nearby. They are not telling, only when you visit portfolio judge, they will mention all these difficulties. Hear their grievances and try to rectify as early as possible. Now, because after holding the high position, now I have gone to the bottom. Every day I am realizing these difficulties. They are coming and informing me so that it can be. Now I used to call Mr. Justice Vaidyanathan, he is not here. He is my administrative judge. Only one paragraph. Before that, 2 months back, I had an opportunity to attend a good function at Ooty, international convent or something. Last 5 years they invited me. I refused. I went there. At that time, Justice Shivaraj Patil, my mentor, former judge of the Supreme Court, also informed me, when you visit Ooty, you attend this graduation day also, pharmacy college. I went there. When after fixing the date, I verified, I am not able to see Mr. Justice Sheshasai. He is the administrative judge of the Nilgiris. I conveyed, brother, I am going to Ooty. I am going to be there for 2 days. If you are free, only on Saturday, please come. We will invite PDJ and all subordinate officers, collector and all subordinate officers up to the level of Tahsildar, Superintendent of Police, all subordinate officers. He readily agreed. In Tamilaham, where the Tamil Nadu House or Tamilaham, very big hall is there. About 300 persons present, they attended. I made a humble lecture and Brother Sheshasai also. At the end, and many police officers and officers working in collectorate, they said, sir, we are unaware of the guidelines to be followed for invoking Gundas Act. You have highlighted. And I said, that's why whenever you pass an order within 2 months, it will be quashed by the High Court. You must follow this. Keep this in your file. This kind of meeting should take place in every month. That's why I am making this humble request. Bar Association are main actor in the legal and judicial system and therefore is critical to any reform. I am confident the legendary Bar Association would be pioneer in this movement of change and adopt creative ways to succeed. Thank you for your attention.
Thank you, Lord, for the elaborate, enlightening, and a speech that is relevant at several factors that touches upon the daily activities of the judicial functioning. Before we move on to the vote of thanks, may I request Louisal Ramesh, the President of the Women Lawyers Association, to kindly honor the dignitaries on the dais. The other office bearers of the Women Lawyers Association can join her. Office bearers of the other bar associations may also join on the stage to quickly honor the dignitaries of the dais. May I request Mr. D. Srinivasan, Secretary of the Madras Bar Association, to give his vote of thanks.
Respected President, Honorable Chief Justice, Honorable Justice Munishwarnath Bhandari, Honorable Justice P.Sathasivam, former Chief Justice of India, Honorable Justice C. Nagapan, former Judge, Supreme Court of India, Honorable Justice Ibrahim Khalifullah, former Judge, Supreme Court of India, Justice N. Pal Vasanta Kumar, former CJ of Jammu and Kashmir, my lords, honorable companion judges of this Honorable High Court and honorable retired judges of this High Court, learned senior advocates, family members and juniors of former presidents of MBA for whom portraits were unveiled today, members of print and digital media, ladies and gentlemen, good evening to one and all. I take this opportunity to propose a vote of thanks. I will make it short and sweet. First of all, I thank the Honorable Chief Justice for having taken his time to visit our association on this function. Thank you, my lords. I thank Honorable Justice P.Sathasivam, former Chief Justice, for consenting to be present here today. Thank you, my lords. On behalf of the Madras Bar Association, a special thanks to you for delivering the lecture and for having travelled this long distance from your native to Chennai. I would like to extend my gratitude to Honorable Justice C. Nagapan for gracing this occasion. Thank you, my lords. I thank the dignitaries on and off the dais, and a special thanks to the family members of the past presidents who are present in such large numbers. A special thanks to the retired judges of this Honorable Court who have assembled in such large numbers. You always remain in our hearts. We also request you to attend the functions of MBA in future. I thank the Honorable sitting judges and the senior advocates and other members of the bar and the registry and print media and the digital media. Thanks to one and all.
I request the audience to raise for the national anthem.